So when a company is incorporated or an LLP is incorporated or any other person with the limited liability that is incorporated. So our constitution article 19(1)(g) says that when any business is opened, the person has the right to close that business at his or her whims and fancies. So anytime the business of the company can be closed, but subject to certain restrictions, because you cannot close the business at any time and without paying all the liabilities and debts. So right to practice any profession or to carry any occupation, trade or business to all the citizens is there in Article 19(1)(g), but subject to certain restrictions imposed on this by the state. The right to carry any business also includes right to close it. So any person who has the right to open the business has the right to close that business, but subject to certain restriction at any time depending upon the desire of the owner. The state cannot compel any citizen to run business which is against his will or which is giving losses to him. But no right is absolute, as the Article 19(1)(g) says. The right to close a business is also not an absolute right. So the primary objective of the voluntary liquidation is to terminate all the operations, sell off all the assets, and dismantle its corporate structure, and to ensure that assets of the corporate person are distributed fairly amongst its creditors and shareholders in a systematic manner, while also promoting a swift and efficient exit from the business. So, while terminating the operations and selling of assets and dismantle the corporate structure, the law says that all the liabilities that has to be paid if the company wants to go in voluntary liquidation, means the company must pay its debts and company must be solvent at the time of taking the decisions by the owners of the corporate person that it is going to be closed voluntarily. So this is the prime objective of the voluntary liquidation. Now, applicability of the provisions of the voluntary liquidation. Under the Companies Act 2013, there were sections 304 to section 303 which were dealing with the voluntary liquidation process, but these sections have never been notified. And when the IBC has come into force, section 255 of the IBC provides that the Companies Act 2013 shall be amended in a manner specified in 11th schedule. And 11th schedule says, by virtue of the notification of 11th schedule of the code with effect from 15th November 2016, various winding up provisions of Companies Act 2013 were amended, and voluntarily winding up sections under the Companies Act 2013 were omitted, and the same have been incorporated in the IBC. And in IBC, only one section is there in the IBC, section 59, which has been notified by the central government on 30th March 2017, and it deals with the only voluntary liquidation of the corporate person with effect from 1st April 2017. And all the provisions which were given under the Companies Act 2013, section 304 to section 323, they have been omitted. And on the very next day, on 31st March 2017, IBBI notified the IBBI Voluntary Liquidation Process Regulation 2017. So this is the, you can say, applicability of the provisions of the voluntary liquidation, that these provisions earlier were given in the Companies Act, and later on these have been incorporated in IBC, and the liquidation process regulations, they have been later on notified by the central government. And now the voluntary liquidation is being taken care of only under the IBC, and there's only one section. And the total provisions, total regulations of voluntary liquidations, they are taking care of the total process of the voluntary liquidation, that how the company and the corporate person can be liquidated voluntarily. Now, the definition of corporate person is given under section 3, subsection 7 of IBC. Corporate person means, under the code, companies incorporated under the Companies Act 2013 or any other previous Companies Act. That is called company, which comes under the definition of a corporate person, which can liquidate itself voluntarily. Second is limited liability partnerships formed and registered under the LLP Act 2008, and any other person incorporated with limited liability under any law for the time being in force, such as insurance companies, banking companies, electricity companies, supply and other companies governed by special acts, except that these companies should not have any inconsistent provisions with the liquidation. Then all these persons also come under the definition of corporate person, and they can be liquidated voluntarily under IBC. But one category is not included in the corporate person, that is, but shall not include any financial service provider as defined under section 3, subsection 17 of IBC. So if any financial service provider company is there, and that is defined under section, which is defined, this activity is defined under section 3, subsection 17, then that cannot be closed as under voluntary liquidation regulations. So any other person incorporated with limited liability under any law for the time being force means what? It is given under section 2B and section 2D of the definition part of IBC. Any other company governed by any special act for the time being in force, and such other body incorporated under any law for the time being in force as the central government may notify. These two terms have been defined under section 2B and 2D of IBC under the definition part. All right. Now, section 59 of chapter 5 deals with the voluntary liquidation of a corporate person. Now, there are conditions for voluntary liquidation. As I in the section of my deliberations, I said that the company can be liquidated voluntarily, but subject to certain restrictions, but subject to certain conditions. What are those conditions? That a corporate person who intends to liquidate itself voluntarily, number one. Number two, has not committed any default. If the company has committed any default, then company cannot be liquidated voluntarily. Means the company must be fully solvent. Means company must be able to pay its debts. Only then the company can be liquidated voluntarily. Then if these two conditions are satisfied, then the corporate person may initiate voluntary liquidation proceedings. Now, default is also defined under the Insolvency and Bankruptcy Code 2016. It means non-payment of debt when whole or any part or installment of the amount of debt has become due and payable and is not repaid by the debtor or the corporate debtor, as the case may be. Means there must be you can say a principle of 3 Ds. There must be a debt, and debt must be due, and there must be a default. Right? So if the company has debt and that has become due, and the company has not paid that debt, means default is there, then the company cannot be closed voluntarily. The company cannot be liquidated voluntarily. So 3Ds, the you can say the test of these 3Ds must be taken care of first before taking up the assignment of voluntary liquidation as IPs. Right now, that means any liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. This is defined under section 3, subsection 11 of IBC. That any liability or obligation in respect of a claim which is due, there must be a due, debt must be due. Only then, if the corporate person doesn't pay that in time, then the corporate person will be in default. If the corporate person will be in default, then voluntary liquidation of that corporate person is not possible under the provisions of law. Now, what are the prerequisites of the initiation of voluntary liquidation? Prerequisites are that this is defined under section 59, subsection 3 and regulation 3 of IBC, Voluntary Liquidation Process Regulations 2017. Before initiation of the voluntary liquidation, the majority of directors of the company or majority of the designated partner of the LLP and individuals constituting governing body in case of corporate persons, a declaration duly verified by an affidavit that is required to be given by the majority of directors and designated partners of LLP and individuals. And what they will write in that declaration? That they have made inquiry into the affairs of the corporate person and formed an opinion that either the corporate person has no debt or it will be able to pay its debts in full out of the sale proceeds of its assets to be sold in liquidation. Now, one thing is required to be understood, that it will be able to pay its debts in full out of the whether that debt has become due or not. That debt has not become due. I already told you that if there is any lack in 3Ds, the initiation of voluntary liquidation cannot be initiated.
Sir, I have a small query out here. So far as these two conditions are to be met, debt and default, in order to opt for voluntary liquidation.
Pardon, your voice is not clear.
I said that means in order to avail the facility or for voluntary liquidation, default and debt both should be there. Should
No,
not be there.
no, those should not be there. No, that may be there, but that has not become due.
Okay.
That should not have become due.
Suppose any statutory liability is due. Suppose any statutory liability is due, but
Yes.
the company, as you said, that company is able to make the payment at that out of the proceeds of assets of the company.
If any statutory liability has become due, then this before initiating the voluntary liquidation process, the company has to pay that liability, and there should not be any default.
Okay, got it.
Before initiating the voluntary liquidation process, the company is required to pay that liability, right?
Right.
No, this is the first condition, that they have made inquiry into the affairs of the corporate person and formed an opinion that either CP has no debt or it will be able to pay debts in full out of the sale proceeds of the assets to be sold in liquidation. And the corporate person is not being liquidated to defraud any person. Means they are not closing the present business of the company to defraud any person. This is also to be written. And now with effect from 31st January 2024, one more condition that has been included, and that is inserted in the declaration, that is the corporate debtor the corporate person has made sufficient provision to meet the obligations arising on account of the pending matters before statutory liabilities. This is
Okay.
also to be included in the
That means all contingent liability needs to be taken care of.
yes, all contingent liabilities to that is to be taken care of.
Yes, sir.
Right?
Please, yes.
Now, such declaration shall be accompanied with the following documents. Now, what are those documents? Number one, the audited financial statements and record of business operations of the corporate person for the previous 2 years. The previous 2 years financial statements and record of business operations that is required to be annexed with the declaration. Right? If the company that is incorporated for less than 2 years, then for that period, suppose if the company is incorporated the last year and you want to liquidate that company voluntarily, then that it is possible. Then, but you will have to annex with the liquidation you can say the financial statements for less than 2 years period. And a valuation report of assets of the corporate person, if any, from the registered valuer. So if the corporate person is having any assets, then valuation report of those assets is required from the registered valuer registered with the IBVI.
So, sorry, it was mandatory?
It is mandatory, sir. It is mandatory. It is mandatory, sir. If the company is having assets, if the corporate person is having assets, then the valuation report from the registered valuer is mandatory, and that is required to be annexed with the declaration.
Sir, you mean to say that fixed assets or intangible assets?
Yes, fixed assets, tangible assets, all.
Tangible assets, fixed and
right,
tangible.
Yes.
Sir, in case there is only bank balance, then?
Yes.
Then that is not required to be valued.
By SFA?
No, that is not required. The bank balance is there. Actually, the purpose of voluntary liquidation is that you will have to liquidate you will have to sell off all the assets, and you will have to collect that money, and that money will come into the bank account of the company, and the bank account from that bank account of the company, the liquidator will pay all the liabilities, and whatever left will be distributed amongst the shareholders of the company, and the account of the company will be closed. And thereafter, the application with the adjudicating authority for dissolution of the corporate person under section 59 subsection 7, that is to be filed. And when the order of the adjudicating authority will come, that will be filed with the ROC, and the ROC will dissolve the company under section 59 subsection 8. This is the total funda which I have told you.
Okay. All right. Thank you, sir.
Right.
Sir, one more thing.
Of the voluntary liquidation. Let me complete my PPT. Your all queries will be settled during PPT.
So one more thing, that is along with the declaration of insolvency, we have to file 2 years financial statement. Suppose we are going right now for voluntary liquidation, then we have to file financial statement for 23-24 and 22-23, or previous to that.
You want to say 23-24. So if you want to start your voluntary liquidation right now, then
yes,
then 23-24 and 22-23 both are required to be filed. And one more thing I would like to share with you, that when you will file the application before the adjudicating authority for seeking the orders for dissolution of the corporate person, the adjudicating authority will also ask you whether you have filed for the balance sheet, the financial statements for the financial year 23-24 with ROC or not. Because adjudicating authority will also issue notice to ROC, and ROC will come and say that they have not filed the financial statements for the financial year 23-24, and your application will be lingered on. So my advice is, my suggestion is that if you are going in voluntary liquidation right now, you please complete your all books of accounts and prepare your financial statements, and place those financial statements before the annual general meeting. call the annual general meeting and file the financial statements as well as annual return with the registrar of companies, so that there should not be any problem or the hindrance at the time of taking orders from the NCLT.
Oh, all right, sir.
Right?
Otherwise, the liquidator has to comply all these.
Otherwise, liquidator will have to comply with. Otherwise, liquidator will not have to comply with, because the company has the time to file those financial statements till 30th October.
Right.
Right? If the voluntary liquidation process goes beyond 270 days, which I will discuss later on, then the liquidator will have to file those financial statements with the ROC. Otherwise, if your voluntary liquidation process that is completed within 90 days, then liquidator is not required to file those. But the ROC, but the NCLT may ask you to file those financial statements, because they want that up-to-date filing with the ROC that is required. And
Sir,
which is not required under section 248 of the Companies Act 2013 when you go for striking of the name of the company. But here, up-to-date filing that is required with the ROC.
So suppose I have already filed the dissolution application under section 59, but it is taking time at NCLT.
Resolution application under section 59, I think there is no resolution application. Dissolution application.
Yeah, dissolution
Okay,
application.
okay. Please continue your query.
Yeah, suppose I have filed a dissolution application 2 years back, but that matter is not matter has not reached as it, and it has not been finalized. So
no. Sir, dissolution and liquidation both are separate parts. Sir,
what I mean to say
liquidation,
that,
sir, you will have to complete the liquidation either in 90 days or 270 days, which is the timeline given in the regulations, right? So when you have completed the liquidation process, means within 90 days or 270 days, whatever.
Right.
After completion of the liquidation process and after winding up all the affairs of the company, only then you have filed the application with the adjudicating authority.
Yes.
Right? So
yes.
Liquidation has been completed.
Yes.
Your application with the adjudicating authority is pending.
Yes.
That may be pending for 2 years, 3 years, 4 years. That doesn't matter.
Okay. So one need not to file that.
No. Your all affairs of the company have been liquidated, have been wound up. No, you need your you can say your assignment as liquidator that has been closed.
Right, sir.
You have filed the application seeking the order of the NCLT for dissolution of the company. Clear?
Yes, sir. Please.
Sir, we have to make a financial statement up to the date of commencement of voluntary liquidation.
Yes, one thing that I'll explain, that from the date of closure of financial year till the date of initiation of voluntary liquidation process, right? For the purpose of so that you must come to know what are the assets and what are the liabilities of the company as on date, or as on the date of the declaration by the directors of the company. So you get these financial statements prepared for your purpose, and that is also required to be filed with the ROC along with the 2 years financial statements we used to file.
Okay.
Because as on date you must know, because during that period, if they have done anything, suppose they have sold any asset after the closure of financial year, but that asset is being shown in the balance sheet on the close of financial year. But if you will get these financial statements prepared as on date, that asset will not come in the balance sheet of the that corporate person.
Sir, where to, like, how to file an ROC, this statement of affairs for this intervening period?
Ma'am, your voice is not clear.
Sir, I'm asking that like from the end of the financial year until suppose today I'm starting that voluntary liquidation, that you said that we need to prepare the statement of affairs. So
Hmm.
how do we file an ROC? There is no
You
such
will not
form.
prepare. You will not prepare. This is the duty of the company. When you will take the assignment as liquidator of that company, you will get the financial statements up to date after the close of financial year till the date when they will appoint you as the liquidator of the company. That it is your duty to take all the assets and liabilities from the corporate debtor, from
Okay,
the
so
corporate person.
they will prepare and give us.
Yes, they will prepare, and otherwise, how you will come to know that what are the assets and what are the liabilities as on date of the corporate person, because they can give you only the financial statements on 31st March. If you are
Yes.
going to start the liquidation process on suppose on 31st May, sorry, on 31st May, in these 2 months, what they have done,
Yes, sir.
they may also pay some liabilities. They may also sell some assets. So as on date, what is the status of the company? What are the assets and what are the liabilities of the company? You must know as liquidator.
Okay.
Thank you.
So we need to file it with ROC in GNL2.
Yes. You must file those because those must be signed by the directors of the company, as well as the auditor may also sign those statements.
For intermittent period also.
Yes, please.
For intermittent period also.
Yes.
2 years. Okay. All right, sir.
Yes.
Thank you.
That is in the, you can say, in the benefit of liquidator also.
So
Right.
that the intervening period financial statement should be termed as a provisional balance sheet.
Provisional balance sheet, no, that is not provisional balance, because company is going to be liquidated, and that for those 2 months period balance sheet, that is not provisional, that is up to date balance sheet.
Okay.
So duly
Right.
audited.
So
It should be duly audited.
yeah,
Duly audited. Duly audited.
it should be audited.
Okay.
It should be audited. Actually, it is not nowhere written in the law and the process. But if it is audited, the auditor must have seen all the, you can say, the ledgers, the cash books, and other books of accounts of the company. Only then that the status of that financial statements as on date, they have been prepared by the you can say promoters of the company.
All right, sir.
Right.
All right,
So,
sir. Thank you.
So disclosure about the pending proceedings or assessments before statutory authorities and pending litigations in respect of corporate debtor, corporate person with effect from 31st January 2024. This third document that has also been included. So these are the prerequisites which are required to be given by the directors of the majority of directors of the company, the designated partners of LLP and individuals, in the form of declaration duly verified by an affidavit, and these documents are to be enclosed with this declaration, right? And now, declaration to list each of the debts. In declaration, the majority of directors, they will list each of the debt of the CP as on the date of making declaration, and they will state that the CP will be able to pay all the debts in full from the proceeds of assets to be sold in liquidation. So they will mention in the declaration. So please prepare the declaration as per laws, so that there should not be any ambiguity or any, you can say, contravention in the declaration. So declaration must be as per the provision, the regulations of the issued by the IBBI. So please prepare this declaration as per the provisions of law.
Sir, that means that liquidator can carry out the process even if there is a debt, but based
Yes.
on the
Yes, why not? Why not? Because if there is a debt and they are making declaration, and in declaration they are writing that the company is able to pay its debts, it means the company is having that much of money in the books of accounts, or they know that the value of their assets, because they have taken the valuer report. From the registered valuer, they have taken the report. They know very well that my assets are suppose rupees 100 and my liabilities are only rupees 80. So they can make declaration. Suppose in future the assets, they can be sold only for rupees 70 and their liabilities are rupees 80. Then what would happen?
Would we call from the shareholders to contribute?
No, what would happen at that time?
At that time,
The
that means
liquidation process,
The process will be reversed, I
withdrawn.
think.
The liquidation process will be closed.
Yes.
They will withdraw. That our company is not able to, because the first two conditions must be complied with for continuous of the liquidation process. So after making declaration, when they have made the declaration, within 4 weeks from such declaration, the corporate person shall pass the special resolution of the members or resolution passed by the special majority of the partners or contributors requiring corporate person to be liquidated voluntarily, and these both conditions they will write in the special resolution, and appointing an insolvency professional to act as liquidator. So these they will within 4 weeks means 28 days. They will pass the special resolution. They will you can say place before the shareholders that we are going to close the company voluntarily, and with 3/4 majority, or in case of LLP with special majority, they will pass the special resolution that the resolution will say that the corporate person is going to be liquidated voluntarily, and they will appoint an insolvency professional. Only insolvency professional can be appointed as liquidator, even if the company is going to be liquidated voluntarily. Now the word is written or. I have underlined the word or. A resolution of the members, partners, contributors of CP requiring the CP to be liquidated voluntarily as a result of expiry of the period of its duration, if any, fixed by the articles or constitutional document. So if the company or the LLP or any other person that has been incorporated for a certain period, and that period is written in the articles of association or the constitutional document, and that duration has been expired or going to expire, then the company will pass a resolution only, not special resolution, resolution by the shareholders that the company is going to be wound up voluntarily. Or second condition is on the occurrence of any event. So if any event has occurred in respect of which the articles or constitutional documents provide that the CP be dissolved as the case may be. So if any event has occurred, what event has occurred? That event is what is that event? That an entity was formed with this specific objective and now it has been fulfilled. So if any entity has been incorporated for a specific objective and that objective has been completed, fulfilled, then the company can be closed voluntarily by passing simple resolution. It is provided by the articles that entities should be liquidated on the occurrence of any event and that event has occurred. Suppose in the articles or any constitutional documents, the certain events have been listed, that if any of these events is occurred, the company will be closed voluntarily, and the company is unable to carry on its business because the company is not able to continue its business, but able to pay its debts, but company is not able to continue its business. So these are the events, then they will
So that means in these circumstances, that liquidation process, voluntary liquidation process will continue and one has to comply with.
Voluntary liquidation process will initiate.
On happening of certain listed
Yes,
activities.
on happening of certain events, the board of directors, they will call the board meeting, and they will, by majority of directors, they will give their declaration along with duly verified by an affidavit, and they will call the meeting of the shareholders. They will pass the special resolution or the resolution, whatever required, and they will appoint liquidator, and the process liquidation voluntary liquidation process that will start.
Okay,
Right?
right.
And now, in case, last line, in case CP owes any debt to any person, the creditors representing 2/3 in value, 2/3 in number, nahi, 2/3 in value of the total debt shall approve the resolution within 7 days of such resolution. So after passing the special resolution or the ordinary resolution, whatever required, if the corporate person is having debts, then the corporate person will have to take the approval of the creditors also within 7 days of passing the resolution. So,
Sir, sir, in this, will it include creditors for expenses also?
creditors means all creditors, financial
Okay,
creditors as well as operational creditors.
so any audit fees, anything is pending, legal fees, so we have to take approval
They
from
are
them.
all creditors.
Okay.
They are all creditors. When here the word is written creditor, creditor means operational creditors as well as financial creditors.
Okay, thank you.
Now, I have 2-3 times I have said that the special majority of the partners oblique contributors. So what is the meaning of contributors? Contributors this word has been defined under the under regulation 2B of the VLP. VLP means voluntary liquidation process regulations. Contributory means a member of the company, partner of the limited liability partnership, and any other person liable to contribute towards the assets of the corporate person in the event of its liquidation. So these are the contributories. So at the time of passing the resolution, these contributories shall pass the special resolution or the resolution, whatever is required.
So
Right.
can you give sir certain example of the third category in the previous slide? Any other person liable to contribute?
Towards the assets of the corporate person. Sir, this is in case of the guarantee companies. There are categories in the companies that if a person has guarantee that at the time of liquidation he will contribute this much of money or this of this much of amount at the time of winding up of the company. So if that person has taken the guarantee, so that person is also be a contributory.
But generally, you will be member also, no? This
That is also that is also a member of the company.
So do you think any person who is not a member still guarantee case would be there?
Sir, sorry, your voice is not your voice is not clear.
So what I'm
Actually,
saying,
yeah,
person who has given a guarantee, will there be a case where who is not a member but still he has guaranteed to contribute to the towards?
Yes, why not? Why not?
Okay.
So, but that person that person will be treated as, you can say, that the company, the voluntary liquidator or the company will ask that person that to contribute
What I'm saying,
that you have
who is
given
not a
the guarantee
member,
to contribute at the time of winding up of the company.
yeah, you mean to say he is not a member, but he has committed to contribute.
Any other person, last you please read the first 3 words. Any other person, not a member.
Okay, okay.
Liable to contribute towards the assets of the corporate person in the event of liquidation.
Liquidation.
If that person is liable to contribute.
Okay, okay, okay.
So that person is also be treated as contributory, right? Now next is resolution. Now has been passed. No special resolution or the ordinary resolution that has been passed. Now, as per the provisions of section 117, if the resolution or special resolution that has been passed, that is to be notified to ROC. Not as per section 117, that is special resolution, but it is these are the regulations which says that resolution to be notified to ROC and IBBI. This CP shall notify to the ROC as well as the IBBI about the resolution to liquidate the company within 7 days of such resolution or the subsequent approval by the creditors as the case may be. So if this special resolution has been passed and there are no creditors, then within 7 days you will have to file this special resolution with the IBBI as well as ROC. And if you have creditors, then after the approval of the creditors, within 7 days of the approval of the creditors, you will have to notify the resolution to ROC as well as IBBI. Right? To both. So, but in case of if we go to the provisions of the Companies Act, they say within 30 days. But regulations say within 7 days. But they means 7 days means 7 days you will have to file the special resolution or the resolution with the ROC as well as IBBI. And for filing the resolution with ROC, there is a forum only for, because we cannot file any or notify anything to ROC in physical form. So there is a form MGT 14 which is required to be filed in case of special resolution or the resolution to ROC. And when we file with the IBBI, we will send an email to the voluntary liquidation department that this special resolution has been passed by the corporate debtor, and they have appointed me as the liquidator of the company. Now liquidation commencement date. So which date will be treated as the liquidation commencement date? The liquidation shall be deemed to have commenced on the date of passing the resolution or subsequent approval of the resolution by 2/3 in value of the creditors. So the liquidation commencement date shall be the date of passing the special resolution or the resolution approved by the creditors. So whichever date is there, that is the date of liquidation commencement date. Now, application of chapter 3 and chapter 7 of IBC. Chapter 3 says the liquidation process, complete liquidation process of the company. The provisions of section 35 to 53 of chapter 3 and the provisions of section 68 to section 77 of that is offenses and penalties, they shall apply to the voluntary liquidation process with such modifications as may be necessary. So these two chapters are also applicable while on the voluntary liquidation process. If you are doing the voluntary liquidation process, then you will have to take care of these sections also. Now, the effect of liquidation. The effect of liquidation under Regulation 4 says that CP shall cease to carry on its business from the liquidation commencement date, except for beneficial winding up of its business. So the CP shall cease to carry on its business from the liquidation commencement date, but it can carry on its business for the beneficial winding up of the corporate person. This corporate person shall continue to exist until it is dissolved under section 59 subsection 8. So it will continue to exist, means the company will be in existence, the LLP will be in existence, the corporate person will be in existence until it is dissolved under section 59 subsection 8. Means when the order of the NCLT, the adjudicating authority, will come and you will file that order with the concerned authority, in case of company and LLP with the registrar of companies, right? So they will approve that the order, and that after approving that that order is filed in form INC 28. There is a forum in the Companies Act 2013 for filing any order of the any authority with ROC, that is for forum INC 28. When you will file form INC 28 with ROC, the ROC will approve that form, and after approval, the status of the company in the master data of the company will be shown like this. Dissolved under section 58 subsection 9. This is one of my company which has been dissolved, and I have taken the screenshot and for the purpose of showing you all participants that the company is dissolved under section 59 subsection 8. Right. Now, appointment of liquidator. So after passing this special resolution and resolution, they will also appoint a liquidator, right? So liquidator under regulation 5, the appointment of liquidator is mentioned. The corporate person shall appoint the insolvency professional as liquidator by passing the resolution, and that liquidator can be replaced by appointing another insolvency professional as liquidator by passing a resolution, special resolution, ordinary resolution, or as per section 59 3C or 3(1), which I have discussed.
Sir, the appointment of liquidator, the resolution would be passed at the time like when liquidation for the corporate person is initiated.
Yes, and the members will pass, and they will appoint the liquidator.
Yes.
Me, when I am talking about the special resolution or the ordinary resolution, that is that can be passed only by the members of the company, not by the board of directors.
That means in the same AGM or EGM, like
yes,
that
in the same
appointment of liquidator has to be considered.
Yes, in the same EGM, they will appoint the liquidator, the insolvency professional as liquidator of the company, right? And
Right.
the resolution appointing insolvency professionals shall contains the terms and conditions of the appointment and remuneration payable to him. Whatever the remuneration will be paid, that will be mentioned in the resolution itself. Right? And the remuneration payable to the insolvency professional as liquidator shall form part of the liquidation cost as per regulation 7. The IP shall intimate the IBBI about his appointment within 7 days. These timelines are to be taken care of very carefully. Please be careful about these timelines, because if you will not follow the timelines given in the regulations, then your voluntary liquidation process will be in soup. Because these are the time. Yes, please.
Yes. Sir, you mean to say that there would be like 2 times like IBBI need to be intimated. One by the corporate person and the other by the liquidator.
No. Corporate person will not. Corporate person will not inform IBBI.
So it is the duty of a liquidator to.
When the resolution is passed, liquidator is appointed. The board is suspended.
No, earlier, you suggested ROC need to be intimated.
ROC need to be intimated. ROC need to be intimated by the insolvency professional, by the liquidator of the company.
On his appointment.
Because when the liquidator will step in the shoes of the directors of the company, he is the in charge of the company. He will inform the ROC as well as the IBBI.
Got it, sir. This is one-time affair. Well, on his appointment, he has to intimate ROC as well as IBBI.
He has to intimate. There is in Form MGD 14, there is a drop down that this form is being filed by whom? The director or the liquidator.
Yes, sir.
So you will file that form. All those forms you will file with the ROC as well as IBBI. Right? So IP shall intimate the IBBI about his appointment within 7 days. With effect from 5th April 2022, this amendment has come that 7 days. Earlier it was 3 days, which was very short period. Now it is 7 days. Now eligibility for appointment of liquidator is there under Regulation 6. Regulation 6 says that insolvency professional and every partner or director of insolvency professional entity must be independent of the corporate person. Independent means he should not have any personal or pecuniary relationship with the corporate person. So every IP and every partner or director of IP entity must be independent. And test of independence is what? Test of independence is number 1, that is eligible to be appointed as independent director on the board of corporate person as per section 149 of the Companies Act 2013. So he must be eligible to be appointed as independent director. This is the test of independence to be appointed as liquidator of the corporate person. He should not be a related party to the corporate person. He should not be related. Related party definitions is given in section 5, subsection 24 and 24A of IBC. He should not be a related party. Third, has not been an employee, proprietor, partner of a firm of auditors of that CP. Auditors means statutory auditors, secretarial auditors, and cost auditors. He should not have been employee, proprietor, partner of a firm of auditors.
Yeah.
Or in case of legal or consulting firm, if the company is having legal or consulting firm that has or had any transaction with the CP contributing 10% or more of the gross turnover of such firm. So this is these are the conditions for taking the, you can say, assignments of voluntary liquidation process of a corporate person. If you fall any of in any of these, then you cannot be appointed as the liquidator at any time in last 3 years. In last two the two conditions, that has not been an employee, proprietor, partner of a firm of auditors of CP, and in case of legal consulting firm that has or had no transaction with the CP contribute 10% or more of the gross turnover of such firm at any time in the last 3 years.
So this declaration also need to be intimated or filed with IBBI or IPA.
Yes. That I'm not related party. When you will give consent, in that consent, you will also write to the corporate person that I'm totally independent. I'm not a related party. I'm not related to any person. I'm not the employee, proprietor, partner of the firm of auditors of the last in the last 3 years. And I am in case of legal consulting firm of the you will all write all these things.
No, I mean to say that it is to be separately intimated to IBBI and IPA, like what we have been doing in.
When you will file your consent with IBBI, within 7 days you will have to file the consent with the IBBI, na?
Okay.
And before the passing the special resolution, at the time of declaration, the board will also consult. The board will also approach you that we want to appoint you the liquidator. So at the time you will also see the whether I am independent or not.
Okay.
Sir, in the
So
previous,
before taking the assignment, you must know that whether you are independent of CP or not.
sir, in the previous slide, you talked about replacement of the liquidator.
Sorry, sir.
So in the previous slide, you talked about replacement of liquidator.
Replacement of liquidator will be there in case of when afterwards you become the you can say the related party.
Only
After
when
becoming
it only when I become related party only there is the
sir, after
replacement.
becoming liquidator, suppose if you become the related party,
But
then
other
you will
scenario,
have to resign.
whether SEC has the power to replace liquidator,
Who?
whether SEC
SEC means?
Sir, SEC is not applicable here.
not applicable here, not applicable. But in case you want to, like shareholders wants to replace, or financial creditors want to replace, or any other creditors want to replace the liquidator.
No, 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 no,
No such
no.
provision.
Once a liquidator is appointed, if that person is independent of CP, that will continue.
So how
We
can
mean
he
to
be removed then, sir?
We meant to say when he becomes
No,
related.
they can't remove the how there is no
There is no
provision
provision.
in the law for removal of liquidator.
You meant to say there is no provision.
There is no provision.
Should
Only one provision is there, that if that person, the liquidator becomes a related party after taking the assignment.
Sir,
The-
appointment.
the-
Sir, appointment is done by the
I-
members. And generally, even under liquidation regulations, it says the appointing authority has power to replace or remove.
No, there is no provision of removal.
There is no provision of removal, but appointment includes replacement.
No, replacement is only actually when the liquidator is appointed. The liquidator has been appointed with the special majority,
True.
right? So if afterwards anybody comes and say that I want to replace the liquidator
With the same majority, can they replace?
with the same majority, no, there is no provision in the law.
There is no
If
explicit
suppose I
provision.
have become an interested party, or I am not eligible to be appointed subsequent to my appointment, to whatever reason, like the valid reason. In that case, how the your IP would be replaced, or it is a voluntary, like I should go and
Who will
intimate.
appoint? Yeah, who will appoint? Good question. In such case, who will appoint in his place some another IP?
The majority,
That means again majority of the.
yes, special majority. Let me discuss, sir. Let me discuss I'll discuss your this query in the coming.
Question answer.
Yeah, please wait for a moment.
Okay. We'll hold this question.
Let me discuss first eligibility for appointment of the liquidator. If insolvency professional or insolvency professional entity of which he is a partner or director is restrained by the order of the board, they cannot be appointed as liquidator. The liquidator shall disclose the existence of any pecuniary or personal relationship with the corporate person or any of its stakeholders as soon as he becomes aware of it, to the board and the registrar. The liquidator shall disclose, right? And IP shall not continue as liquidator if IPE of which he is a director or partner or any other partner or director of such IPE represents any other stakeholder in the same liquidation process. So they cannot be now. No, the replacement can be the liquidator can be replaced. Yes, liquidator can be replaced if afterwards, after appointing the liquidator falls within the test of independence. Only then it can be replaced. Otherwise, there is no provision of removal of liquidator.
Sir, who is the replacing authority as
The members, the shareholders with these same majority, they can replace the shareholder. The liquidator.
Would you just enlighten the process? Suppose I have become ineligible, so I have to intimate to to whom?
You will have to intimate to the IBBI.
Yes, IBBI.
Right, and the board and the board of directors of the company.
So then say again.
They will pass they will call the shareholder meeting, and the shareholder will pass the resolution or the resolution for replacement of the liquidator.
The board is suspended, no?
Board is suspended, no?
If board is they can call the shareholder meeting, no? They will not call the board meeting.
No, they said their office is all vacated. They see that is order of liquidation, unlike the provisions in the normal liquidation.
But shareholders are not suspended.
Shareholders can.
No,
shareholders are not suspended. Shareholder meeting will be called.
See whether the existing liquidator has to inform shareholders.
Even liquidator can call the meetings of the shareholders.
Well, that could be an ideal scenario.
Yes.
Right. Now, next, after taking the assignment as liquidator of the corporate person, the first step is to make public announcement in Form A of Schedule 1 under Regulation 14. They will make public announcement. The liquidator will make public announcement within 5 days. Within 5 days of his appointment. These the timelines are very important. You please take care of. I'm repeating again and again. In 2 newspapers, that is one in English and one in regional language in wide circulation at the location of the registered office, number 1. Number 2, at the principal office of corporate person. Third, any other location where, in the opinion of the liquidator, the CP conducts material business operations. So in all 3 places, the liquidator will publish in 2 newspapers, one in English and the other is in the regional language, which must be in wide circulation. The public announcement in Form A of Schedule 1 and also on the website of the CP and on the website designated by the board for this purpose, if any. And purpose of the announcement is what? That he will call the stakeholders for submission of their claims as on the liquidation commencement date. Whatever the claims they have, if they please file their claims. Then in Form A, he will write the last date for filing the claims with the liquidator. Provide the last date for submission of the claim, which shall be 30 days from the liquidation commencement date. It should be 30 days. It is written in the provisions and in the regulations, and that there shall be mentioned in the Form A, which shall be published in the 2 newspapers. Now, notice to the concerned assessing officer under Section 178 of the Income Tax Act 1961. Notice is required to be given to the assessing officer. But I am discussing these provisions here because in case of liquidation, it is required. Notice of appointment to be given to the concerned assessing officer within 30 days of appointment, right? And within 3 months, assessing officer shall notify the amount of tax payable by the company. If any pending dues are there, if they have any claim, liquidator cannot part with any assets of the company without the prior permission of the principal, CCID, PCID, and commissioner. Any contravention of the above provisions, liquidator shall be personally liable to pay the tax of the company. Now, these are the timelines which are against the voluntary liquidation process. There are other timelines given in the voluntary liquidation process, right? So he will note here it is written under Section 178 that within 3 months, assessing officer shall notify the amount of tax by the payable by the company, whereas we are writing in Form A that you will have to notify within 30 days. Otherwise your claim will not be taken. You're taken on record. But the last provision says the provisions of this section shall have effect notwithstanding anything to the contrary contained in any other law for the time being in force, except the provisions of the Insolvency and Bankruptcy Code. Right? The provisions of this section shall have effect. So, except the provisions. So, provisions of the Insolvency and Bankruptcy Code, they will be, you can say, they will supersede the provisions of the Income Tax 1961. So, the provisions of the IBC, they will be, you can say, they will be in force, except means the provisions of Income Tax Act will not be applicable in case of voluntary liquidation process. The provisions of the regulations given in the voluntary liquidation process, they will be applicable. Now, the registers and books of accounts Regulation 10 says that if the books of accounts of the corporate person as on the liquidation commencement date are incomplete, then the liquidator shall have them completed with all convenient speed. If they are completed, then it's okay, right? The liquidator shall keep receipts for all payments made or expenses incurred by him. These are the simple provisions, and these are the registers and books of accounts which are required to be maintained by the liquidator. And these are the cash book, ledger, bank ledger, register of fixed assets and inventories, securities and investment registers, register of book debts and outstanding debts, tenant ledger, suit register, decree register, register of claim and dividends, contributories ledger, distribution register, fee register, suspense register, documents register, books register, register of unclaimed dividends and undistributed proceeds. And with effect from 15th January 2020, this has been included. And why this has been included, I will discuss later on, because this is required to be maintained by the liquidator, and it is important register which is required. Such other books and registers as may be necessary to account for transaction of CP. All the aforesaid registers and books are maintained in the the forms in Schedule 2 with all necessary modifications as per the requirement of the liquidator. So these registers are required to be maintained by the liquidator. Now, what are the professionals and engagement of the professionals the liquidator can make? This is given Regulation 11. Regulation 11 says liquidator may engage the professionals to assist him at a reasonable remuneration, and such remuneration shall form part of the liquidation cost. So reasonable remuneration, the liquidator can engage the professionals, and that will be the part of the liquidation cost. The liquidator shall not engage a professional who is a relative or related party of CP. Here must be the test of independence is applicable, or has served as an auditor to the CP at any time during 5 years preceding the liquidation commencement date. He will not engage any professional. Now, professional engaged or proposed to be engaged shall disclose the existence of any pecuniary or personal relationship with any of the stakeholders or CP as soon as become aware of it to the liquidator. So professionally, if any professional engaged and subsequently he will disclose the existence of any pecuniary or personal relationship with the stakeholder or CP. So as he after subsequently, if the professional engaged comes to know that I have any pecuniary or personal relationship with any stakeholder of the CP, he will disclose to the liquidator. Now, consultation with the stakeholders. Regulation 12 says that the liquidator has the power to consult any of the stakeholders entitled for distribution of the proceeds under Section 53. So all the stakeholders, for stakeholders means the creditors as well as the shareholders. They are the stakeholders. So the liquidator has power to consult them, right? And the stakeholders consulted under Section 35 subsection 2. This is the regulation which is in you can say in consistence with Section 35 subsection 2. The stakeholder consulted shall extend all assistance and cooperation to the liquidator to complete the liquidation of the corporate person. And the liquidator shall maintain the particulars of any consultation with the stakeholders made under this regulation. So he will maintain all the particulars of any consultation. Now, this was regarding the consultation with the stakeholders. Now, extortionate credit transactions the regulation 13 says that extortionate credit transaction under section 50, because as already told you that section 35 to 53 are also applicable on chapter 3 of are applicable upon the liquidation process. So section 50 says that extortionate credit transaction under section means where terms of receiving financial or operational debt within 2 years preceding the insolvency commencement date. What term says? Require the CP, corporate person, to make exorbitant payment in respect of the financial or operational debt received. That is extortionate credit transaction. Means if that transaction is exorbitant, means that is above the natural principle of business, then that is extortionate credit transaction and are unconscionable under the principle of law relating to contracts. Then that is to be treated as extortionate credit transaction. Section 50 subsection 2 says board may specify the circumstances in which the transaction shall be covered under section 50 subsection 1. Any debt extended by any person providing financial services which is in compliance with the law for the time being in force in relation to such debt shall in no event to be considered as an extortionate credit transaction. So if any debt is extended which is in compliance with the provisions of the law for the timing in force, that does not be treated as extortionate credit transaction. This is regulation 13. So the liquidator has been appointed. The liquidator has filed all the you can say the resolution specialized with the ROC, RB, IBBI. The liquidator has also published in the newspaper. The liquidator also mentioned the 30 days date in the in Form A Schedule 1 for filing the claims of the by the claimants. Then what he will do after that? He will wait for 30 days, and within 30 days, if any claim comes, then the person who is filing claim will prove his claim. The provisions of claims, these are given in regulations 15 to 19. The person who claims to be stakeholder shall prove his claim for debt or dues to him, including interest, if any, on the liquidation commencement date under regulation 15, and proof of claim to be sent in the following manner. Proof of claim, how the proof of claim will be sent? In case of operational creditor other than the workman employee, except workman or employee, only the operational creditor shall submit the proof of a claim to the liquidator in person or by post or by electronic means in Form B of Schedule 1. There is a Form B given in the regulations for filing the claim by the operational creditor other than the workman or the liquidator. And in case of financial creditor, the financial creditor shall submit the proof of claim to the liquidator in electronic means in Form C of Schedule 1. Right? Now, in case of workman or employee, they will submit their proof of claim to the liquidator in person or by post or by electronic means in Form D of Schedule 1. These are the forms which are given, which are categorized for each category, that they will file their claim in these forms only. In case of numerous workmen or employees, any authorized representative may submit one proof of claim for all such dues on their behalf in Form E of Schedule 1. So one person can be authorized representative in case of numerous workmen or employee, and their authorized representative will file the claim of all in Form E of Schedule 1. Person claiming to the stakeholder other than the aforesaid. So if there are other stakeholders other than which are mentioned in the previous regulations, then they shall submit proof of claim to the liquidator in person or by post or by electronic means in form F. So form B, C, D, E, F, these are the forms mentioned in the regulations in which the stakeholders, they will file their claims. The stakeholders will file their claims as per their category mentioned in the regulations. So now chapter 5, basis of proof of claims. On what basis they will file their proof of claim? In case of operational creditor, the existence of debt may be proved on the basis of what basis? Number 1, records available with the information utility. So if there is any record available with the information utility, the operational creditor will prove the basis of claim on the basis of that. Number 2, contract for supply of goods or services. If there is any contract of supply of goods or services is signed by the corporate person and the operational creditor, that will be filed with the liquidator along with the invoice demanding payment for the same to the corporate person. Order of the court or tribunal that has adjudicated upon non-payment of debt, if any, and financial accounts of the CP. So these are the documents which are required to be filed along with the form by the operational creditors, form B, right? And they will annex all these documents in support of their claim. And in case of financial creditors, the existence of debt may be proved on the basis of records available with the information utility and financial contracts supported by financial statement, record evidencing that amount committed by the financial creditor to this corporate person under a facility has been withdrawn by CP. Right? Well, that record is required to be submitted, and financial statement showing that debt has not been repaid, and the order of the court or tribunal that has adjudicated upon the non-payment of debt, if any, under regulation 17 sub-regulation 8. So these are the documents which are required to be annexed with the form in support of the claim which is being filed by the financial creditor. Now, further, in case of workman and employee, the existence of debt may be proved on the basis of number 1, records available with the information utility. This is common in all. Proof of employment, such as contract of employment for the period of claim, right? If the contract, or you can say you have the appointment letter, right? Notice demanding payment of unpaid amount or other proof that the payment has not been made. Order of a court or tribunal that has adjudicated upon the non-payment of debt, that is also a proof which can be annexed with the form to be filed by the workman and employee. Now the liquidator shall admit the claims of the workmen or employees on the basis of books of accounts of CP if such workman or employee has not made any claim. Because workman or employee, they may be illiterate, they are only of, you can say, the workman, they are working in the plant or the factory of the CP, so they are not aware about all these nitty-gritties of the provisions of law. So liquidator the liquidator shall admit the claims on the basis of the books of accounts being maintained by CP, and that can be added in the you can say liability. The basis of proof of claims next says that in case of other stakeholders, the existence of debt may be proved on the basis of record available with the information utility, the documentary evidence of the notice demanding payment of the unpaid amount, or a bank statement of the claimant showing that claim has not been repaid, along with the affidavit that the documentary evidence and the bank statements are true, valid, and genuine. So in case of other stakeholders other than which we have discussed, operational creditor, financial creditors, workman, employee, if any other person, that will have to file the affidavit or along with the affidavit that the notice for demanding the payment and the bank statement which they are filing, they are annexing with the form that is true and valid and genuine. Documentary or electronic evidence of his shareholding. Documentary or electronic evidence of his shareholding. So here question arises whether the shareholders of the company, of the corporate person, they will also file the claim.
Yes, sir.
Yes, they will also file the claim with the liquidator. That, and what would be the evidence of their shareholding?
Their
The
share certificates.
The share certificates.
Or if shares are like, for DP statement.
Or DP statement. Yes, depository party statement that as on date, I am the shareholder of these shares. They will also file their claim with the liquidator.
So in the
Order
claim,
of the,
sir, I
yes,
found out here in the claim form of the shareholders.
sir, your voice is not clear.
Sorry,
Please.
sir, in the claim form of the shareholders,
Yes.
there is one column which requires the amount to be mentioned. How much? What is the claim amount?
What is the claim amount?
Claim amount.
No, claim amount. Their claim amount. Their claim amount shall be because they cannot mention the claim amount.
Claim amount. Why? They are not
Because whatever will be the left, that may be more, that may be less.
Yeah, it may be more, it may be less. So generally, what is suggested? Like they should leave that claim amount to column blank.
No, they may leave
Can it be less, sir?
that column they may leave that column empty, or they may write that whatever as per whatever my share will be after paying all the liabilities, that will be acceptable to me.
Yeah. So they can't.
They can mention the paid up value, sir.
Face
Paid
value.
up value.
They mention equal face value, paid up face value.
They may mention face value, but they may mention face value if they no if there is an amount more than the face value, then how the liquidator will pay?
Residual value can be written, sir.
Yes.
Residual value.
How will the shareholder will come to know residual value?
Residual value, yes, residual amount. They can write that residual amount will be acceptable to us.
Simply they should say residual value.
I am also liquidating so many companies which are in which the shareholders, they are getting more than the face value.
True, but how do you fill the column? This is the question now.
No,
Residual value, whatever will be left after paying.
IPOs we write as cut-off value. So in the same way, residual value will be the whatever residual it can be.
Yes. They can write this.
Yeah.
Right.
Sir, have you come across such a kind of situation wherein you had to go for valuation of shares? And giving a fair value and the liquidation
valuation
value?
of share is not required, sir. Valuation of share is not required. The valuation of assets is required.
Okay.
We are not
Valuation of shares is not required
here, right?
because whatever left, that will go to the shareholders. They cannot say no. They cannot say yes.
Yes.
But in case there is an investment in equity, I think that needs valuation.
Yeah,
that is the asset of the company, sir.
Yes.
Yeah, that is the I am saying if the company is having asset, if the company is having any investment in shares, then that is required to be valued.
No need to value its own shares.
Yes.
No need to value its own shares.
No need to value
its own shares.
Its own shares.
I could not.
No, it means to say, sir, that I'm the shareholder. I cannot value my shares of my own.
No. Because you are the shareholder of that company, only the assets of the company are required to be valued.
No.
If you are shareholder,
Yes, sir. One more thing. Suppose, I have misplaced my shares and the company has gone into voluntary liquidation. I came to know about this during the process. So how to take care of this such kind of cases?
no, actually, when the company will call the shareholder meeting, at that time you will come to know that.
Suppose I am not in India. I am somewhere outside India, and I came to know little
then
very
then
late.
you can you can file your claim with the
Affidavit.
liquidator, and if you have misplaced your shares, you will have to file an FIR.
All those
filing
kind
a
of
claim,
indemnity and
And you will have to when you will file the you will have to another thing, the maybe in the Companies Act 2013, that if you have misplaced the shares, first you will have to file FIR, you will have to give indemnity bond, you will have to give an affidavit to the liquidator that I am the shareholder of this company, and the liquidator will match your shareholding, whatever you are claiming, with the list of shareholders filed with the Registrar of Companies, the latest shareholding filed with the Registrar of Companies.
the basic question lies here: is it mandatory that no shareholder should submit his claim form?
Sir, it is mandatory. It is we have discussed right now, no? The documentary. Then now you please read the C point. Documentary evidence or electronic evidence of his shareholding.
You mean to say if there is no claim form, you will not pay him? Equity
Pardon?
shareholder. No, if one of the equity shareholder member does not submit a claim form,
Does
so
not submit a claim form.
then what is the consequence? Will not distribute to him, or he will transfer to this voluntary liquidation account?
No. It is the duty of the liquidator to get this the claim form from the shareholders. He will
No,
write to the shareholder that you file your
Yes.
claims.
he might
Yes.
write, but it is not a duty, no, sir. Duty is to
No,
duty lies with the
not
shareholder.
it is not the duty, but
It's a good practice.
yeah, but
Maybe good
it is
practice,
normal
but
practice that we used to ask them to file their claims,
claim
and
form.
we take their claims within time.
And
So
at the
I'm
same
saying,
time, there are
Because
laws.
I'm
because
saying
sir, it is because it is his or her interest also. They will
true.
get money.
Sir, in case
Why they will not file their claim?
there are scenario, in fact, I have my personal experience where one of the shareholder did not submit a claim. I had transferred the amount to liquidation account, voluntary liquidation account.
You can because that person because that person is also on the list of the shareholders.
Yes, he is part of the list of shareholder, but he did
Because
not submit a claim
because
form.
he's the shareholder of the company.
Yes.
So I used to take the claim forms from the shareholders, and they file their claims. Nobody says no.
No, there are cases. One case I had, practically one case. Unless
But practically you are right. Practically you are right. If shareholder doesn't file his or her claim, he is entitled to the amount whatever he is his share.
No, I'm
But
saying
as per the regulations,
your transfer.
as per the regulations, shareholder must file their claim.
Must file the claim. If it doesn't file the claim, well, option left with the liquidator is to transfer that amount to voluntary liquidation account.
Yeah.
Thank you,
The
sir.
liquidator will transfer definitely because he has the list of shareholders with him, filed by the company with the ROC, the corporate person has to file the list of shareholders with the ROC, latest list of shareholders with the ROC, and they will also give the list of stakeholders to the liquidator also.
True, but in my case, just to add you, one of the shareholder, no, in spite of my follow-ups, in spite of calling them also, he did not submit it.
Even then he is entitled, sir.
No, he is entitled, sir. What I'm saying, what is the option left to the liquidator? Because liquidator has to distribute all the amount, then only go for file application for dissolution.
Yeah.
So, but in the option,
This is the practical problem.
yeah.
But when a shareholder is giving the account number, the RTGS account number, everything he or she is giving.
No, if he's not giving, the question is if he's not giving
Claim.
claim form.
No, if he's not giving, then
Liquidator has left with no option.
then that person will be then there will be unclaimed amount that will be treated as unclaimed amount.
Wait, that amount liquidator
That
has to
amount shall be
transfer.
transferred. That amount shall be transferred as per regulation 39, which I will discuss later on.
Yeah, okay.
If there is no claimant, if any shareholder is not sharing his account number, RTGS account number, or if you send him a check, if you send him a DD, that DD comes back to you, that is unclaimed amount. If that is unclaimed amount, that is required to be deposited with the liquidation account opened by IBBI in relation to that corporate person. And regulation 39 I will discuss later on, because this is given very, you can say very length. This is explained very clearly in regulation 39. So I'll discuss later on your query I think will be settled at that time, right? Now let me complete my PPT and proof of security of interest. Proof of security interest regulation 20. The existence of security interest may be proved by a secured creditor. If a secured creditor is there, that how that secured creditor will prove his security interest. That will file a record available with the information utility. Number 2, certificate of registration of charge issued by the registrar of companies. And proof of registration of charge with the Central Registry of Securitization, Asset Reconstruction and Security Interest of India, CERSAI. If they have filed their charge with the CERSAI, they can prove the registration of charge. And they also other relevant documents which adequately establish the security interest. So these documents are required to be annexed along with by the financial creditors or secured creditors. Now, production of bill of entry or promissory note. Now, the proof a debt in respect of bill of exchange, promissory note, or other negotiable instrument or security of a like nature for which CP is liable. Such instrument shall be produced before the liquidator before the claim is admitted. If there is any bill of exchange or promissory note or other negotiable instrument or security of like nature, then that is required to be produced before the liquidator before the claim is admitted. Substantiation of claims. The liquidator may call for such other evidence or clarification as he deems fit from the claimant for substantiating the whole or part of its claims. So it is the discretion of the liquidator that if he wants to further strengthen his belief that this claimant is reasonable and this is genuine, then he may call further evidences. Now, cost of proof of claim. Now, who will bear the cost of proof of claim? Regulation 23 says that the claimant shall bear the cost of proving its claim, and the cost for verification and determination of claim incurred by the liquidator shall be part of the liquidation cost. So if there is any cost comes for verification and determination of the claim, so if he engage any professional, suppose for the verification and determination of the claim, so the salary or the remuneration of that professional, that will be part of the liquidation cost. If a claim is found false, suppose if anybody files a claim and that comes out to be false, then the liquidator shall endeavor to recover the costs incurred for verification and determination of the claim from such claimant and shall provide the details of the claimant to the board. Right? Now, the determination of quantum of claim. Regulation 24 says where the amount claimed by the claimant is not precise. If that is not clear, then Due to any contingency or any other reason, the liquidator shall make the best estimate of the amount of his claim. This is also discretion given to the liquidator. But in case if the amount is claimed by the claimant is not precise, based on the consultation with the claimant and the corporate person and the information available with him. So he will make the best of the estimate. Now the valuation of debt in foreign currency. So if any debt is there in the corporate person which is in the foreign currency, then how that is to be calculated. Claims denominated in foreign currency shall be valued in Indian currency at the official exchange rate on the liquidation commencement date. Now, what is the official exchange rate? Official exchange rate is the reference rate published by RBI or derived from such reference rates. So this is to be calculated as of the liquidation commencement date in Indian currency. Now, there are many other claims which will be filed with the which may be filed with the liquidator, and these claims are to be tackled with number one, the periodical payments, just like rent, interest, or such other payments of periodical nature. The person may claim only for the amounts due and unpaid up to the liquidation commencement date, not after that. Means up to the liquidation commencement date, they can claim the periodical payments, and that will be taken care of by the liquidator.
Sir, suppose there is a lease existing as on date of liquidation. So, like, it would be prudent to, to take care of that, or we have to terminate the lease. Whose duty is this?
If there is any lease agreement, and whatever the amount will be calculated, the amount of the lease will be calculated as on the liquidation commencement date.
No, that is okay. My question is something sir different. My question is, suppose that the lease is subsisting. Lease is still continuing.
No, lease is if the lease will not be continued after the liquidation commencement date. If lease is continued, that will not be paid. That claim will not be taken care.
But the leaseholder should be intimated about the liquidation process. Huh?
Definitely. Because that person is the owner of that property. That will be given, you can say, the notice the company is has gone into liquidation, and your claim, you can file your claim up to the date of liquidation commencement date. After that, your claim will not be admitted.
Yes.
Sir, office and
company property is leased out.
The properties will be there, sir, until the disposal of those movable properties. The office and the assets will be there, the furnitures, until the disposal. During that time also the premises will be there, no, sir?
No. You are saying that there may be assets on the leasehold land.
Yes.
Right, but as per regulation, the claim will be only up to the date up to the liquidation commencement date.
But why I being a lesser, I should be like give you my premises to use.
Pardon?
See, suppose I have a claim up to the date of liquidation. Then why should I allow a liquidator? Suppose if I'm a leaseholder, why should I allow a liquidator to continue and enjoy my property without making additional payment to me?
This is the practical problem. This is the practical problem, but as per regulation, the payment can be made only up to the liquidation commencement date.
Can the voluntary liquidation
be included in can it be included in the liquidation cost?
Pardon?
Sir, when there is a long lease, of a property owned by CD, can you propose a voluntary liquidation in such case? Because lessee will claim that no, he has right to use the property for beyond 1 year period, 2 year period.
Sir, your voice is not clear, please.
Not clear.
Sir, lease expenses beyond the commencement date can be included in the liquidation cost, sir.
Huh? No. Actually, this is mentioned in the regulations that in case of rent, interest or such other payments of periodical nature, the person may claim only for the amounts due and unpaid up to the liquidation commencement date. Means the person who is the lessor, he may claim only for the amounts due and unpaid up to the liquidation commencement date.
It's a very,
Not after that.
very peculiar kind of situation. Like,
This is very peculiar kind of situation, sir. Because the claim there has to be a cutoff date for the claims, no? Claims cannot be continue forever.
That's true, but like, because it is under a process. So like unless until the entire assets like, are liquidated or like, it is sold off, like, I could take out my assets from that premises to in a open field.
Because actually when the liquidator is appointed, that liquidator, you can say, is the officer of the court, right? And that person that person will sold all the assets as soon as possible. You can say within a period of within as soon as possible. Not, you can say that we cannot mention any period, but that person can sell the assets. And in most of the companies, this is the practical problem. This practical problem comes in those companies which are having you can say many assets. But in most of the companies used to sell all the assets before before initiating the liquidation process. They used to sell all the assets, and they used to, you can say, there are only, you can say, the bank balance and the cash in hand, or some other, you can say, the debtors, some small debtors are there. So in most of the cases, in liquidation, voluntary liquidation process, the companies, they used to sell all the assets.
And sir, as per your experience, what is the overlapping time between the commencement date and final distribution, as per your experience?
No, I used to complete the liquidation process within 90 days because before whenever a corporate person comes to you for voluntary liquidation and wants to appoint you as liquidator, then we used to suggest and restructure their the balance sheet, and we used to say them that you pass the resolution or special resolution and sell the assets and take the value report and sell the assets accordingly and deposit the amount in the bank account. If you have any cash and bank balance, you also deposit in the bank account. So there should not be any you can say the assets, the major assets, because if you will appoint a liquidator, the liquidator will have to sell those assets as per the provisions of the law, and that may take time. And the process of liquidation, the liquidation process may be longer. So
is there any possibility of like, sir, is there any possibility of like, directors entering into an kind of arrangement with the leaseholder that, okay, this much time is going to take for the liquidation process. So I'm just, making some kind of provision for say 90 days or say more than 90 days.
That is, you can say, out of the law.
Okay.
They can do. They can also say that okay, the liquidation process will go for 90 days. For 3 months, we will pay you the lease rent from our own. But you can claim only up to the date of liquidation commencement date. After that, we will they can enter into an MOU.
And sir, suppose I make an application seeking direction or giving immunity to adjudicating authority. Is it possible, sir, for just to accommodate this kind of time difference?
Pardon, your voice has cut.
I
You
said,
please-
can I move an application before adjudicating authority for giving me the immunity for this 90 days so that, at least, my process,
No,
sail through.
no.
No, no.
So if you have creditors, you can complete your process within 270 days. If you don't have any creditors, then you can complete your process within 90 days. And 90 days time is more than sufficient.
Great, sir.
So I will discuss all your queries later on in my PPT. Right? You please let me go through my PPT. Then I will have your queries. Now, debt payable at future time. So if any debt is payable at future time and that has not become due yet, that can be calculated with the formula given here. That can be admitted. Now, mutual credits and set off. Mutual credit means I have to pay 100 rupees and other have to pay 70 rupees. The mutual set off only 30 rupees I have to pay, right? Now, claims, verification of claims. Then verification of claims, regulation 29 says liquidator shall verify the claims submitted within 30 days from the last date for receipt of claims. Means within 30 days, the liquidator shall verify all the claims received by him, and then after verification, liquidator may either admit or reject the claim in whole or in part as the case may be, as per section 40 of the code. As per the provisions of section 40, if liquidator rejects the claim, then he shall record the reasons for rejection in writing. You please record the reasons for rejection in writing. If you will not record the reasons for rejection in writing, then that is not a rejection. This is written in the law. It is my experience that when I filed the application before the adjudicating authority, I received the claim from the income tax department that at that time I have distributed all the amounts to even to the shareholders also, and I filed the application before the adjudicating authority. And in the mail, I wrote all the reasons for rejection. That I cannot accept your claim because this is time barred. And as per so and so regulation, as per so and so section, so that is required. Otherwise, that will not be treated as rejection. The liquidator shall communicate his decision of admission or rejection to the of the claim to the creditor or the corporate debtor within 7 days of such admission or rejection of the claim. Shall also communicate his decision, and creditor may appeal to the adjudicating authority against the decision of the liquidator within 14 days from the receipt of decision as per section 42 of the code. So they can also file an appeal with the NCLT that our rejection, our claim may be admitted, may kindly be admitted within 14 days. Right? So now the list of stakeholders. Liquidator shall prepare the list of the stakeholders on the basis of proof of claim submitted and accepted with the amount of claim admitted, extent to which the debts or dues are secured or unsecured, details of the secured stakeholders, and proof of claims admitted or rejected in part or rejected wholly. So he will prepare the list of stakeholders and will mention all these things, all these details. Liquidator shall prepare such list within 45 days from the last date of receipt of claims. So within 45 days from the last date of receipt of claims means 30 days plus 45 days means 75 days. He will prepare the list of stakeholders. He will prepare the the list of stakeholders within 45 days. Provided that where no claim is received till the last date of receipt of claim, liquidator shall prepare the list of stakeholders within 15 days. So if the liquidator has received the claims, then the period is given 45 days. If no claim is received, then 15 days. Time period is given. Now, list of stakeholders as modified from time to time shall be available for inspection by the persons submitted proof of claims. So the list of stakeholders that is available for inspection by the persons who have submitted the proof of claims and by the members, partners, directors, and guarantors of the corporate person, and that is also to be displayed on the website of the corporate person or designated by the board for this purpose. Now, the realization of assets. Now, manner of sale. If there are assets in the company, in the corporate person, how that can be sold out? The liquidator may value and sell the assets of CP in the manner and mode approved by CP in compliance with the provisions, if any, in the applicable statute. So, asset include assets, all assets, set of assets, parcel of assets, as the case may be in relation to the sale of assets. Now, recovery of monies due. Liquidator shall endeavor to recover all and realize all the assets and dues to the CP in a time-bound manner for the maximization of the value of the stakeholders. Now, Chapter 6 says realization of assets, Regulation 30 to 33, 31 to 33, realize uncalled share capital or unpaid share capital contribution. Liquidator shall realize the amount due from the contributory to the CP. Liquidator shall entitled to call and realize the uncalled capital and the arrears, if any, due on the calls made prior to the liquidation commencement date of CP by providing a notice to the contributor to make the payment within 15 days from the receipt of the notice. So he will give a notice to the contributory that you have the arrears, the CP has arrears, and you have not paid the amount on calls. You are required to make the payment within 15 days from the date of receipt of this notice. You please pay, and he will realize that amount from the contributory. In case the calls are encumbered or charged. So if the calls are encumbered or the calls are charged, then the liquidator shall hold all the monies realized subject to the rights of the holders of such charge or encumbrance, because the right of the charge holder is first. No distribution shall be made to the contributory unless he makes his contribution towards uncalled or unpaid capital as required in the constitutional document of CP. If he doesn't make payment, then the distribution, last distribution to the shareholders will not be made. So the proceeds of liquidation and the distribution, how that is to be made. Now, money to be, all money is collected from the sale of assets or from the debtors, even from the current assets, that money to be paid to the bank account. Liquidator shall open a bank account in the name of the CP, followed by the words involuntary liquidation. Please be ensured that your account is opened in the bank account with the words involuntary liquidation in the scheduled bank only for the receipt of all monies due to the CP. And liquidator shall pay to the credit of the bank account opened under subregulation 1 all the monies including checks and demand drafts received by him as liquidator of CP. He will pay to the credit. He will not keep it with him. And the time given is that the realization of each day shall be deposited into the bank account without any deduction, not later than next working day. He cannot deduct any amount from that amount which he has realized. He will deposit the whole amount not later than the next day in the bank account opened with the words involuntary liquidation. Money in the credit of the bank account shall not be used except in accordance with section 53, means distribution. Except distribution, the money cannot be used. All payments above 5,000 rupees shall be made by check, drawn, or online banking transaction against the bank account. Now, the rule 35 says within 30 days from the receipt of the amount, the liquidator shall make the payment within 30 days from the receipt of the amount with effect from 5th April 2022. This provision has been made. Earlier it was 6 months. That was too longer period. Now it is 30 days. Deduction of liquidation cost before the distribution, that is required. With the approval of the CP, distribution of an asset that cannot be readily or advantageously sold to its peculiar nature or other special circumstances among the stakeholders. So with the approval of CP, the asset can be distributed among the stakeholders if that is of peculiar nature or having any special circumstances. Now, return of money. Stakeholders shall immediately return the money received in distribution for which he was not entitled. If any distribution has been made inadvertently to any person and that person was not entitled to that amount, that person will return the money immediately, right? Now the tax liability. Tax liability, it is not given in the regulations. As per section 2, section 22C of the Income Tax Act 1995, any distribution made to the stakeholders of a company on its liquidation to the extent to which the distribution is attributable to the accumulated profits of the company immediately before liquidation, whether capitalized or not, shall be deemed dividend. Now it is required to be understood that in a simple way, if I can explain this, anything which you are distributing to the shareholders above their share capital, that is deemed dividend, and that is to be that will be taxed, and it is the duty of the liquidator that on deemed dividend TDS at the rate of 10% is payable, and that liquidator shall deduct 10% TDS and will deposit with the income tax department. This is the example which I have mentioned here, that for example, paid up share capital of XYZ company in voluntary liquidation is 50 lakh rupees. Suppose the amount realized from the asset of the company is 80 lakh rupees. After payment of liabilities, the amount available for distribution is 75 lakh rupees. Now 50 lakh is the repayment of capital only to the amount above 50 lakh is 25 lakh will be deemed dividend, and it will be taxed, and at TDS at the rate of 10%, that is 2,50,000 shall be deducted and paid to the income tax authorities. To deduct and deposit TDS is the responsibility of the liquidator only, right?
Sir, hello.
Gee.
Sir, share premium is treated as accumulated profit.
Yes.
Share premium.
You play. Can you speak loudly? Actually, your voice is not.
Share premium is treated as accumulated profit, sir, for this purpose.
Share premium.
Yeah.
Share premium is the part of the capital.
So it is not accumulated.
Actually, share premium is not the profit. Is not the part of you can say the profit which the company has earned.
Okay. So
Share
today,
premium has been paid by the by the shareholder.
so we can repay the share premium,
Yes, you can
not
pay the
deducting any TDS, not deeming it to be a dividend.
pardon.
We need not deem it as a dividend when we pay
It is not.
repay
It is
the
not dividend because share premium the company has taken the premium on the shares.
Okay.
No, you can say it is not it is not the operational income of the company.
Yes, sir. Yes, sir. That's right. Thank you.
The shareholders are subject to capital gains tax under section 46 on assets distributed or money received after deducting deemed dividend from the money received or fair market value of the asset on the date of distribution. They will be subject to capital gains. The capital gain will be levied upon the shareholders who are receiving the money as well as the assets, right? Now difference will be paid. They will pay the difference. Whatever I have to dispose, I have deducted 10%. They are falling in the category of 20%. Now 10% I have deducted, 10% they will pay. Now the next is reporting by the liquidator. How the liquidator will report? The first is the preliminary report. The submission of preliminary report to the corporate person. It is not to IBBI, it is not to ROC. It is to the corporate person within 45 days from the liquidation commencement date. Detailing what he will write in the preliminary report: capital structure of the corporate person, estimates of assets and liabilities as on the liquidation commencement date on the basis of books of corporate person. If liquidator has reasons to believe that books of corporate person are not reliable, then such estimates based on the reliable records and data otherwise available to him, right? He will report on these estimates of assets and liabilities. Whether he intends to make any further inquiry into the matter related to the promotion, formation or failure of CP or conduct of the business thereof, he will also write in the preliminary report. Proposed plan of action for carrying out liquidation along with the estimates of liquidation costs and timelines within which he proposes to carry out the liquidation. So this is the preliminary report. This is the preliminary report which now preliminary report shall be prepared and submitted. Liquidator shall prepare the preliminary report, status report, minutes of the consultation with the stakeholders, and final report in the manner specified under the regulation. The liquidator shall make available the aforesaid reports, preliminary report, status report that is been inserted in the regulation with effect from 31st January 2024. The liquidator shall make available the aforesaid reports and minutes to the stakeholders either in electronic or physical form on receipt of an application in writing and cost of making such reports available to them. He will make available, right? And also obtain an undertaking from the stakeholders that they shall maintain confidentiality of such reports and shall not use the same to cause any undue gain or loss to itself or to any other person. Now, liquidator shall endeavor. Now, this is the timeline that within which you will have to complete the liquidation process. The liquidator shall endeavor to complete the liquidation process and submit his final report within 270 days from the liquidation commencement date where the creditors have approved the resolution. Means if the company is having creditors, if the corporate person is having creditors, then he will complete the liquidation process within 270 days, otherwise 90 days. If the company is not having any creditors. Earlier it was 12 months. Now it is 90 days period. The company is not having any creditors or there are only assets, then only 90 days period is given. If liquidation process continues for more than 270 days or 90 days, then what the liquidator will do? The liquidator shall hold a meeting of the contributories within 15 days from the end of 270 days or 90 days as the case may be. And thereafter, at the end of every succeeding 270 days or 90 days from the liquidation commencement date, till the submission of application for dissolution of the CP with the adjudicating authority. So the meeting of contributories only after 90 days or 270 days period if that has expired, and after every expiry of 90 days and 270 days, the meeting of the contributories will be held. Now, liquidator shall make a status report indicating progress in the liquidation, which includes the settlement of the list of stakeholders. If in case the liquidation goes beyond 90 days or 270 days, only then the liquidator will call the meeting of the stakeholders and make a status report. Otherwise, status report is not required to be made. Status report is required to be made only if there is a meeting of the stakeholders after the expiry of 90 days and 270 days as the case may be. The liquidator shall make a status report indicating progress in liquidation, which includes settlement of the list of stakeholders, details of any assets remains unsold or unrealized, distribution of proceeds and sold assets made to the stakeholders, developments in any material litigation by or against the corporate person, filing of and developments in the applications for avoidance of undervalued transactions in accordance with Chapter 3 and Part 2 of the Code, and reasons for not completing the process within the time stipulated and the additional time required for completing the process. This is with effect from 31st January 2024. This regulation has been amended, Regulation 37. Now, status report shall enclose the audited accounts showing the receipts and payments of liquidation since the liquidation commencement date. With every status report, the liquidator shall have to annex the audited account showing the receipt and payments. Since the liquidation commencement date, the liquidator shall file the status report with the board within 7 days of the meeting with the contributors. So status report will be prepared and filed with the IBBI only if the liquidation goes beyond 90 days or 270 days, only then, otherwise not required. Now, final report. On completion of the liquidation process, if all the assets have been realized, all the liabilities have been made, tax TD has been deposited, now the bank account that has been closed. Now, on completion of the liquidation process, now liquidation process is completed. Now, what the liquidator will do, liquidator shall prepare the final report consisting of audited accounts showing receipts and payments of the liquidation since the liquidation commencement date. Number 2, this statement demonstrating assets of CP has been disposed of, debts of CP has been discharged to the satisfaction of the creditors, and no litigation is pending against CP, or sufficient provision has been made to meet obligations arising from any pending litigation. So then final report shall also state sale statement with regard to all assets reflecting realized value, cost of realization, manner and mode of sale, person to whom the sale is made. An explanation for shortfall if realized value is less than the registered value in asset valuation report of the registered valuer and any other relevant details for the sale. Liquidator shall submit the final report and compliance certificate in Form H. Form H is there. Now, without Form H, the final report will not be filed. And in all the when you will file the application with the adjudicating authority, the adjudicating authority will see Form H, whether that is annexed with the final report, because the Form H is from the liquidation commencement date till the winding up till the liquidation of the company. All the timelines, all the compliances are written in Form H, along with the application for dissolution of CP to the adjudicating authority, that the liquidator shall submit the final report and the compliance certificate. These are the timelines which I have mentioned, I think, which I have already discussed in you can say during my presentation. Now, application to the adjudicating authority. Section 59, section 7, 8, and 9 deals with the application, where the affairs of the CP have been completely wound up and its assets completely liquidated. The liquidator shall make an application to the adjudicating authority. Adjudicating authority, on application filed by the liquidator, they will pass an order for dissolution of the CP, which I have shown you that one of my company which I have dissolved under section 59 subsection 8. Right, copy of the order under subsection 8 shall within 14 days from the date of such order be forwarded to ROC. Now, Form INC 28 is there in the Companies Act 2013, which is required to be filed with the ROC for all orders of all the courts, including the tribunals. If all the order of the courts and tribunals, they are to be filed with ROC in Form INC 28, right? That is required to be filed with the ROC within 14 days. Now, if there is any unclaimed proceed or undistributed assets of liquidation, Regulation 39 deals with that. It says the board shall operate and maintain an account to be called Corporate Voluntary Liquidation Account, CVL account, in the public accounts of India. If there is any unclaimed proceeds, undistributed assets of liquidation, then board shall operate and maintain an account to be called Corporate Voluntary Liquidation Account in public accounts of India. The liquidator shall deposit the amount of the unclaimed dividend, undistributed proceeds, if any, along with any income earned thereon, till the date of deposit, or holds any amount on the date of commencement of IBBI VLP Amendment Regulations 2020 within 15 days before submitting the application to the adjudicating authority. So he will deposit all the unclaimed dividend and undistributed proceeds in that account. If the liquidator fails to deposit the aforesaid amount, then the same shall be deposited along with 12% interest per annum thereon from the due date of deposit till to the date of deposit. And the liquidator shall submit the evidence of deposit of the amount to the ROC and IBBI, and a statement in Form G setting forth the nature of the deposit along with the names and address of the stakeholders entitled to receive the unclaimed dividend or undistributed proceeds. He will file a Form G with the IBBI and ROC along with the evidence of deposit of the amount with in the aforesaid account. The liquidator shall be entitled to get a receipt from the board for any amount deposited in the said account. Now, this regulation 39 that has been amended with effect from 31st January 2024, and according to that amendment, Regulation 39 sub-regulation 7A to E have been included in the Regulation 39. Prior to dissolution of CP, a stakeholder who claims to be entitled to any amount deposited into the CVL account may apply to the liquidator in Form I for withdrawal of the amount. He will apply to the liquidator. And what the liquidator will do after verification, the liquidator shall request the board to release the amount to him for distribution to the stakeholders. Right? On receipt of the request, the board may release the amount to the liquidator. He will release the amount to the liquidator, and the liquidator, after making distribution, shall intimate to the adjudicating authority of such distribution. And after dissolution of CP, a stakeholder may apply to the board in forum I for an order for withdrawal of the amount. You know, this is the because till dissolution, the stakeholder will approach to the liquidator, and after dissolution, the stakeholder shall apply to the board in forum I, otherwise to the liquidator. If there is no, if the company, the corporate debtor has not, the corporate person has not been dissolved, then the liquidator to the liquidator, after dissolution to the board. If any other person other than the stakeholder claims to be entitled to any amount, shall submit evidence to satisfy the liquidator or the board regarding his entitlement. And if the board is satisfied that the stakeholder or the person other than the stakeholder is entitled to withdraw any amount from CVL account, may make an order in favor of that person. Now, board shall maintain corporate person-wise ledger of the amount deposited or withdrawn from the account. Now, it is the duty of the board. The board will nominate an officer as the custodian of the account, not below the level of executive director of the board, and no proceeds shall be withdrawn without his approval. Uski approval, he is approved. Without his approval, no, even not a single penny can be withdrawn. He will maintain proper accounts and get the same audited annually and placed before the governing board, and shall be forwarded to the central government. And the amount deposited into CVL account which remains unclaimed or undistributed for a period of more than and any income or interest received in the said account after the completion of 15 years from the date of dissolution of CP shall be transferred to the Consolidated Fund of India. Right? Now, the circumstances under which adjudicating authority may order for suspension of detection of fraud or insolvency. If liquidator is of the opinion, Regulation 40 says, if liquidator is of the opinion that liquidation is being done to defraud any person, if any time you comes to know that it is the liquidation is being done to defraud any person, and the CP will not be able to pay its debts. These are the two conditions, right? In full form, the proceeds of the assets to be sold in the liquidation, he shall make an application to the adjudicating authority to suspend the board process of liquidation, and the adjudicating authority may pass any such order as it deems fit. So in this way, the suspension of the voluntary liquidation can be made. Now, preservation of records. Regulation 41 says the liquidator shall preserve physical or the electronic copy of the reports, registers, or books of accounts for at least 8 years after the dissolution of the CP. So, as liquidator, you will have to maintain the books of accounts. You will have to books of accounts and the registers after the dissolution of CP for 8 years. Now, can voluntary liquidation be stayed or withdrawn after its initiation? Yes. Neither IBC nor Companies Act 2013 contains any express provisions for withdrawal of voluntary winding up after its initiation. There are no provisions. However, Section 60, subsection 5 of IBC 2016 and Section 280 of the Companies Act 2013 provides for jurisdiction of the NCLT to entertain or dispose of any application or proceedings by or against CP, or any question of priorities, or any question of law or facts arising out of or in relation to liquidation proceedings of CP under this code. So you may make an application under section 60 subsection 5 to the NCLT of IBC and section 280 of the Companies Act 2013.
Sir, the books and the records of the corporate debtor is to be maintained for 8 years.
Yes.
And thereafter, like, how to destroy it?
After 8 years, you can destroy.
Do we need to take any?
Actually, after 8 years, you need not to maintain those, and you need not to maintain the books of accounts and the papers. You can destroy. Actually, earlier in the Companies Act, there were rules.
Yes.
For destroying the records by ROC only, but not by the liquidator.
Okay.
So you
there is no
can
provision.
destroy in any way. No. And Rule 11 of NCLT rules also gives the inherent powers to the NCLT. Nothing in these rules shall be deemed to do, limit, or otherwise affect the inherent powers of the tribunal to make such orders as may be necessary for meeting the ends of justice or prevent abuse of process of the tribunal. So they have the inherent powers under Rule 11, and you can make application under section 60 subsection 5 to stay or withdraw the voluntary liquidation after initiation. There are so many case laws for withdrawal of liquidation. In case of Honorable Allahabad High Court, in the matter of Dhankari Investments Limited versus official liquidator, adjudicated that this power includes the power to stay the voluntarily winding up itself together when court is satisfied that the causes for which the voluntarily winding up resolution was passed no longer exists. So there are other these are the cases, and the court further says that that this power should be exercised sparingly and only where it is just beneficial and expedient to do so. Otherwise, not. Now, further in one matter, VV Purohit versus Gadag, Jambukeshwara, and another, the Karnataka High Court, while disposing of the application for staying the voluntarily winding up of the company, observed that if the stakeholders have resolved to revive the company and make one more effort to start the cement factory, opportunity should not be denied to them. In these circumstances, the prayers in these applications are granted. So the courts have also stayed or withdrawn the liquidation process. Now the benefits of voluntary liquidation. What are the benefits? Benefits is the controlled. It is the controlled exit. Means exit from the market in a controlled manner, minimizing disruptions and ensuring an organized distribution of assets. Because you are taking as shareholder, the shareholders, they are taking the decision of voluntarily winding up the company. So, and they are appointing an insolvency professional as the liquidator, and liquidator is appointing. So there is no intervention of any other person, and it is very controlled exit. And second is transparency, involvement of creditors and shareholder in the liquidation process, thereby avoiding potential conflicts, because both are creditors as well as shareholders. They are approving the voluntary liquidation process, and this is very efficient also because it streamlines the winding up process, enabling a quicker resolution compared to the traditional methods. And stakeholder protection is also there. The interest of the creditors, stakeholders, and other stakeholders are safeguarded through the regulated and fair process. And legal recognition, the IBC provides legal framework for voluntary liquidation, offering legitimacy to the process. So this is all about the voluntary liquidation process.
Sir, request you to share the PPT with Institute.
Yeah, definitely I will share the PPT with the ICSI, and they will share with you.
Yes.
Sir, I wanted
Please.
to ask one question. Like, suppose the voluntary liquidation is started on 31st May. So for
Hmm.
pending litigations, the law requires everything, all the estimations have been made. Now,
Hmm.
suppose income tax, GST, or any other department, after the liquidation starts, for previous assessment years, if they make any assessment, issue any notice, and then what happens? And suppose we do not have the funds, then what happens?
If you don't have the funds, I think I have discussed one thing. You just give me 1 minute. I have in that case, the the shareholders to whom the payment has been made, they will make the payment, because they were not entitled to that amount, because that amount was not at that time came to my knowledge.
Yes.
And you please take the indemnity bond, which I do. This is other than the you can say law, which I'm telling you. I take the indemnity bonds and affidavits from the shareholders, all the shareholders, that in case any liability comes in future, they will pay that amount, because when I made the payment to them, they were not entitled to that payment which they have received,
Yes.
and which is also written written in the regulations also, that if they are not entitled to the payment, then they will return that payment to the to the corporate person, to the you can say, it is written in rule 36. Rule 36 says stakeholder shall return the money received in distribution for which he was not entitled. So if any liability comes in future, it means that was to be paid first before making the payment to the shareholders.
Yes, sir.
So shareholders were not entitled to that payment which they have received. So it is their duty to return or make the payment to the stakeholder.
Okay, sir. And so one more question, like we have income tax refund. So till we get that refund, we cannot file for dissolution. So what is the method? Like, can we apply to the income tax, or how does it happen practically?
Practically, it happens that first you ask the before initiating the liquidation process, you ask your corporate person to get that refund first, because if the company, if we will not file dissolution every 90 days, or after every 270 days, you will have to hold the meeting of the stakeholder, and you will have to put the agenda in the meeting that we have not received the income tax refund. That is that is why we are not able to file the application with the adjudicating authority for dissolution of the corporate person.
So it's better that they
It
do
is
it, and
better.
after that.
It is better that if they get the refund from the income tax department as soon as possible.
Okay, sir. And so during the liquidation process, if there is an income, so that audit, everything we have to, the liquidator has to get it done.
Deposit that amount in the bank account opened with the schedule pending, followed by the words involuntary liquidation. You will have to deposit that amount.
No, sir. What I'm asking is, the FD incomes are like more, so I have to get the tax audit done, statutory audit done. I have to file GST returns till
But
dissolution.
if tax audit is applicable, then definitely tax audit will be there.
So all compliances we have to
But in
complete.
most of the cases, I think tax audit is not there.
So for ours, like we have funds, so income, we are getting income. So tax audit will be applicable.
If tax audit is applicable, then you will have to make the tax audit.
So we all provisions have to be made for appointment of professional. All amount has to be available.
Yes, you will have to appoint. You can engage professionals. This
Okay.
is provided in the regulations.
Yes. Okay, sir.
Sir, you said that annual status report has to be prepared after 90 days and 270 days. I think it is for the annual status report, so it should be after 12
No,
months
sir.
only.
No, sir. If after 90 days you call the meeting of the stakeholders.
Sir, 37.2 says it is annual in the event of liquidation process continuing more than 12 months.
Sir, it was earlier.
No, I am having latest book, sir.
Just hold on. Let me check. Liquidator shall make a status report. It is not annual status report. Regulation 37.
37.2, sir.
37(2). In the event the liquidation process continuing for more than the period stipulated in sub-regulation 1, this has been amended with 31st January 2024. The liquidator shall hold a meeting of the contributories of the corporate person within 15 days from the end of 270 days or 90 days as the case may be, and thereafter at the end of every succeeding 270 days or 90 days as the case may be, as stipulated in sub-regulation 1 till the submission of application for dissolution of the corporate person.
Oh, I'm sorry, sir.
So
Thank you.
whatever regulations you were reading, that was prior. Now with effect from 31st January 2024, it has been amended.
Thank you, sir.
Please, sir.
Mr. Gupta, good afternoon.
Good afternoon.
I'm Venugopal Panika here. Just wanted to quickly check one thing. Are Section 8 companies also covered under voluntary liquidation?
Which
Or
section?
Section 8 companies, not for profit companies.
Yes.
Are they also covered? Can we directly go in for
Yes,
their...
yes. Why not? All companies, sir.
Okay.
All companies are covered. I'm also liquidating one Section 8 company.
Okay, great. Thank you. Bye.
Sir, I have query. Sir, Girish here.
Please.
Hello.
Please,
Sir,
please.
we have the foreign investors, stakeholders, and they are not filing the claim for the stakeholders' purpose. So how to go about this, sir? We have sent the letters, we have sent the emails. What to do? How many time we have to wait for that?
So no. You need not to wait for them. You have given 30 days time. You have sent mails. You have also communicated to them. If they are not filing their claims, it's okay. Their claim will not be admitted. You please.
So I can go directly for the dissolution, make yes, the payment and give it to the IBB and complete the process.
Yes, if they are not filing their claim, then what you can do?
Okay, sir. Thank you so much.
It is them to file their claim. They are not filing their claim.
Hello.
Then they will not get anything.
Hello.
Yes, please.
Sir, on passing of the special resolution, the company has to inform IBBI. Or the liquidator will anyways inform IBBI on his appointment. So, will the company also need to inform IBBI as written in the regulations? And if so, how does the company inform?
Company is not required to file.
I think the language written that is in the regulation is written. The company has to inform IBBI on passing of the special resolution.
Which regulation?
I think so. Just a sec. I'll just let me check.
Yes, sir. This is the same question I had put forward.
Oh, which?
One sec, sir. I'm just.
It is written, the insolvency professional shall within 7 days of his appointment as liquidator intimate the board about such appointment. It is regulation 5 sub-regulation 2. It is regulation 5 sub-regulation 2.
That's for the liquidator.
It has been amended with effect from 5th August 2020.
Yes, that's for the liquidator to inform. So liquidator will only need to inform.
Yes.
Okay, so give me a... Okay, sir.
Regulation 3, sub-regulation 2.
Somebody is writing that please share your contact number. Can you see this this screen? Just hold on. Just hold on. I'm sharing my screen to you also. No. This is my contact number and email ID also. Whether Nidhi companies can be voluntarily liquidated. Nidhi companies are financial service providers, I think so. They are not. They cannot be liquidated voluntarily. It is written in the regulations itself.
If you don't follow up with your new contract within 1 or 2 days, you have just limited the entire network. So these are the tips. Basically, there are many more things. But first thing is that we have to sacrifice for that thing. We be prepared for that.
Yes, any query?
The session is open to share your experience, your own tips to understand that well for the growing networking. You can share your experience, your knowledge, your gain about improving the network. So,
Sir, it is regulation 3, regulation 3, sub-regulation 2. The CP shall notify the ROC and IVA about resolution to liquidate the company within 7 days of such resolution.
Notify that no. Notify regarding what? Regarding the initiation of regarding passing this special resolution.
All right. So
it is regarding
CP.
It is regarding resolution.
Resolution.
And the appointment of
CP will notify
resolution,
in MGT 14. And how it will notify IBBI? CP?
Notify to the ROC. I told you during my presentation that the corporate person will file form MGT 14 for the resolution with ROC.
But how to IBBI? CP shall notify ROC and the IBBI.
By email you can send your this resolution and your appointment. And within 7 days you will have to file your consent with IBBI on its website.
All right. That is regarding the appointment.
Yes, that is regarding the appointment.
True. So CP has nothing to do.
Yes.
All right. Sir. Thank you.
Yes, sir.
So thank you. If you have any query, please let me know. I am available. Otherwise, should I close my PPT and should I close the presentation? And should I close the session also?
Thank you, sir. Thank you very much.
Thank you very much. Thank you all. Thanks a lot. for sparing your valuable time. And
Thank you, sir.
thank you very much to all for listening me patiently. Thanks a lot.
Thank you very much, sir, for such a knowledgeable and insightful session. Sir, you are requested to please share your PPT.